There are mornings in this courthouse that feel like the world is exactly as it should be. The kind of mornings where Christina brings me her strong Italian coffee at 8:20, the docket is sitting clean on my desk, the Providence sun is coming through the courtroom windows at just the right angle, and for a few quiet minutes before the doors open and the day begins, everything feels orderly and purposeful. I have been sitting on this bench for 23 years. My father, God rest him, used to say that a man who loves his work is the richest man alive. On mornings like that one, I believed him completely. That Tuesday morning in October started exactly that way. Christina set the coffee down beside my docket at 8:17, 3 minutes early, which meant she was in a good mood. I wrapped both hands around the cup the way I always do when the Providence chill starts coming through the old courthouse walls, and I started going through the names. Routine hearings, mostly. A few traffic violations, a small claims dispute, a pair of noise ordinance cases that would be resolved in under 10 minutes each. Nothing unusual. Nothing that made me set down the cup. And then I saw the name. Tyler Brennan. 19 years old. The charges underneath it stopped me cold. Reckless driving. Hit and run. Fleeing the scene of an accident. 3 separate offenses from a single incident 3 weeks earlier on a Wednesday evening. I read the incident report slowly, the way I always do when something about a case tells me there is more beneath the surface than the charges alone can describe. A residential street. A 58-mile-per-hour speed in a 25 zone. A parked vehicle struck. A fire hydrant. A sidewalk. And then the part that made me put the coffee down entirely, a pedestrian. Injured. Hospitalized. And Tyler Brennan running on foot 2 blocks from the scene before officers caught up to him. I have been in this courtroom long enough to know that a case file is never just paper. It is a story about people. And this particular story had the kind of details that settle into your chest and stay there. Christina came to my bench about 10 minutes before the session was set to begin, and she leaned in the way she does when she wants to say something quietly. "Judge," she said, "this one is a little unusual today." I asked her what she meant. She told me the gallery was fuller than it normally is for a Tuesday morning docket, and that there was a woman sitting in the front row who had been there since the doors opened. Arrived before anyone else. Just sitting. Very still. I asked if the woman was a family member of the defendant. Christina shook her head. She said she didn't know who the woman was, but that there was something about the way she was sitting that had stayed with her since she first walked in. Like she had been preparing for this moment for a long time. I filed that away and finished my coffee. At 9 o'clock on the dot, the doors at the back of the courtroom opened and the morning's defendants began filtering in. I recognized the rhythm of it, the nervous ones who sit forward, the resigned ones who lean back, the first-timers who look around at everything like they are trying to memorize the room in case someone asks them to describe it later. It is a particular kind of human theater, a Tuesday morning docket, and after 23 years I can read the room the way a musician reads a sheet of music before the first note is played. Tyler Brennan walked in at 9:06. I noticed him immediately, not because he was loud or disruptive, but because of the way he moved. He came through the door like he was walking through a hallway in his own house, not nervous, not respectful, not even particularly aware that he was somewhere that required a certain kind of attention. Designer sneakers. Expensive streetwear jacket with a logo I didn't recognize but that looked like it cost more than most people in that room made in a day. 1 AirPod in his left ear. The right earbud hanging loose against his collar, which I suppose was his version of a concession to the setting. He looked around the courtroom once, the way you glance at a waiting room to find an empty seat, and then he dropped himself into a chair in the front row on the defendant's side with the kind of heavy, deliberate slouch that told me sitting here was something being done to him rather than something he had chosen. Before he had been seated 10 seconds, he had his phone out. I want to tell you something about that moment, because people sometimes ask me what it is that signals trouble before a single word has been spoken in a hearing. It is not the clothes. It is not the age. I have had teenagers in this courtroom who showed more dignity and self-possession than men twice their age, and I have had grown adults in expensive suits behave like children the moment they felt their comfort was being inconvenienced. What signals trouble is the absence of awareness. The inability, or the refusal, to recognize that you are somewhere that exists for a reason larger than your own schedule. Tyler Brennan had no awareness of this room whatsoever. None. And in my experience, that particular kind of unawareness does not arrive alone. It brings company. Across the aisle, in the first row of the gallery, sat the woman Christina had mentioned. Mrs. Eleanor Watts. 67 years old, though I did not know her name yet. She was small and she sat very straight, wearing a plain gray coat that had been carefully pressed. Her hands were folded in her lap with a deliberateness that told me the folding was intentional, that she had decided, before she walked through that door, that she was going to hold herself together completely and that folding her hands was part of how she was going to do it. There was a purse on her lap, and tucked into the outer pocket of the purse was the edge of a photograph. I could see just the corner of it. 2 people. Outdoors somewhere. I could not make out more than that from where I sat. She was looking at Tyler Brennan. Not with anger. Not with the wet, open expression of fresh grief. With something else, something that took me a moment to identify, and when I identified it, it was the thing that stayed with me longest about that entire morning. She was looking at him the way you look at something you have been trying to understand for 3 weeks and still cannot quite make sense of. Not hatred. Not even pain. Just a quiet, devastating bewilderment at how a person could exist the way he was existing right now, in this room, with what he had done sitting in the court file on my desk. Christina stood at her station. All rise for the Honorable Judge Caprio. Every person in that courtroom stood. The elderly man near the back. The young woman with a folder pressed to her chest. The 2 lawyers by the wall. Mrs. Eleanor Watts, slowly, carefully, both hands pressing down on the edge of the bench in front of her to help herself up. Tyler Brennan did not move. He sat with his phone in his hand and his one AirPod in his ear, and he did not stand. In 23 years on this bench, I had never heard the words that boy was about to shout at me in open court. And I can tell you this, by the time he finished the sentence, neither had he. I have a rule in my courtroom that I have kept for 23 years without exception. When I walk through that door and Christina calls the room to order, every person present rises. Not because of me personally. Not because of the robe or the title or the years behind it. They rise because of what this room represents, because the law that operates inside these 4 walls belongs to every person who has ever needed it, and standing when it convenes is the smallest possible acknowledgement of that fact. It costs nothing. It requires nothing except the basic recognition that you are somewhere that matters. Tyler Brennan had not stood. And so before I called a single case, before I said a single word about charges or evidence or what this morning was going to look like, I sat down, folded my hands on the bench in front of me, and looked directly at him. Mr. Brennan, I said. This courtroom has a standard of conduct that applies to everyone who enters it. When the court is called to order, you stand. He looked up from his phone slowly, the way teenagers look up when they have decided to acknowledge you but want you to know the acknowledgement is a gift they are choosing to give rather than something you are entitled to receive. He stood. Not quickly. Not with any particular expression of understanding. He stood the way someone stands when they have decided that standing is the fastest route back to sitting, and then he sat back down before Christina had even finished settling at her station. I noted it. I noted all of it. And I called the first case of the morning. We moved through 2 routine matters before Christina called Tyler's case at 9:24. I watched him stand and approach the bench, and I want to describe that walk carefully because it told me everything I needed to know about what the next 20 minutes were going to look like. He did not walk the way nervous people walk, with that slight hesitation in the step that comes from understanding the weight of where you are headed. He did not walk the way resigned people walk either, with the heavy, measured pace of someone who knows what is coming and has made peace with it. He walked the way someone walks when they are confident the thing they are walking toward is not going to be as serious as other people seem to think. Loose in the shoulders. Unhurried. The AirPod still in his left ear. The phone still in his right hand, screen down now, as if screen down was the version of phone holding appropriate for a courtroom appearance. "Mr. Brennan," I said, "please remove the earbuds." He reached up and pulled the left one out, the one that had been in since he arrived, and tucked it into his jacket pocket. The right one was already hanging against his collar. He did not remove that one. He left it there, dangling, and looked at me with an expression that was not quite a smirk but was close enough to one that the distinction did not matter much. I decided not to address the second earbud. Not yet. There would be time for that conversation, and it was not the conversation I needed to have first. I opened the case file. I have read thousands of incident reports in this courtroom over 23 years, and I have learned that the way you read them aloud matters. Not dramatically. Not with inflection designed to make the defendant feel something. Just clearly. Just factually. Because the facts, when they are read clearly and without embellishment, are almost always more devastating than any performance could make them. 3 weeks ago, I said, on a Wednesday evening at 6:15 p.m., you drove your vehicle through a residential intersection on Callaway Street at 58 miles per hour. The posted speed limit on that street is 25 miles per hour. You struck a parked vehicle on the right side of the road, lost control of your car, and your vehicle mounted the sidewalk. A fire hydrant was struck. You then exited your vehicle and fled the scene on foot. Officers apprehended you approximately 2 blocks away, 7 minutes after the incident was reported by witnesses. I closed the file. Those are the charges, Mr. Brennan. Reckless driving, hit and run, and fleeing the scene of an accident. Do you understand what you are charged with? He shifted his weight to 1 foot. Yeah, he said. I understand. I looked at him and waited, the way I always wait, because in my experience people who have more to say will say it if you give them the space, and people who have nothing to say will fill the space anyway just to end the silence. Tyler Brennan filled it in about 4 seconds. Look, he said, I panicked. It was a mistake. I know I shouldn't have run, but I was scared and I made a bad call. I'm 19. That's what he said. I'm 19. Like the number itself was a legal argument. Like being 19 was a sentencing guideline he expected me to consult before deciding what any of this meant. I want to tell you what I was thinking in that moment, because it is important for what came next. I was not angry. Anger is not useful in this courtroom, and I learned that a long time ago. What I felt was something more specific, a recognition that this young man had constructed an explanation for himself that had no room in it for anyone else. In his version of 3 weeks ago, there was a car and a bad decision and a scared 19-year-old who panicked. That was the whole story. That was where the story began and ended. I looked over at Mrs. Eleanor Watts. She was sitting exactly as she had been since the doors opened. Straight. Hands folded. The photograph still tucked into the outer pocket of her purse. Mrs. Watts, I said, please come forward. She pressed both hands against the bench in front of her and stood. I watched her do it and I understood immediately what Christina had meant that morning, that there was something about this woman that stayed with you. She was small, as I said. Fine-boned. The kind of small that looks delicate from a distance but carries something in it up close that is anything but. She moved carefully, with a deliberateness in each step that was not the deliberateness of age alone. It was the deliberateness of someone who had recently been hurt badly enough that moving through the world required a degree of conscious attention it had not required before. She was learning her body again. You could see it in the way she placed each foot. In the way her left arm stayed slightly close to her side, protective of the wrist underneath the sleeve of her coat. She reached the front of the courtroom and stood beside the defendant's table, a few feet from Tyler Brennan, and she faced me. Your Honor, she said. Her voice was quiet. Not fragile, quiet. There is a difference. Fragile things tremble. Her voice was simply soft and precise, like someone who had decided exactly what she was going to say before she came here and was not going to waste a single word of it. She told me what happened. She had been walking on Calloway Street at 6:15 on a Wednesday evening, coming back from the market 2 blocks from her house with 2 bags of groceries. She did not see the car until she heard it. The sound of it, she said, was the thing she remembered most, the sound of an engine moving much too fast through a neighborhood where things moved slowly. She had just enough time to turn toward the sound before the car struck the parked vehicle and she was hit by the force of the fire hydrant being torn from its base 6 feet away. It caught her on her left side. She went down on the pavement. Her groceries scattered. She lay there for a few minutes before anyone reached her because the witnesses had first run toward the car. 2 broken ribs. A fractured wrist. For days in Providence Memorial. At 67, with osteoporosis that she had been managing for 3 years, the fracture required a plate and 3 screws. She was still in physical therapy. She would be for another 4 months. The courtroom was very quiet. But then she said something that I did not expect, and I have been in this courtroom long enough that there are not many things left that I do not expect. She said, "Your Honor, those injuries are not why I am here today." I looked at her. She reached into the outer pocket of her purse and she placed a photograph on the edge of my bench with her good hand. I looked down at it. 2 people, younger, walking along a tree-lined street on what looked like a summer evening. The woman was clearly Eleanor. The man beside her was tall, with his hands in his pockets and his face turned slightly toward her, mid-conversation. "That is Harold," she said. "My husband. We walked that route on Calloway Street every Wednesday evening for 31 years. It was our thing. Just ours. He passed away 2 years ago in August." She paused. She did not look away from me. After he was gone, I kept walking it. Every Wednesday, same time, same route. Because when I walk it, I can still feel him beside me. I can still hear him talking. It was the one place in the week where the grief got quiet for a little while. Her voice did not break. She had promised herself it would not, and it did not. "That boy," she said, "did not just hurt my body, Your Honor. He took away the one place I still had where Harold felt close to me. I cannot walk that street anymore. Not the way I used to. Not the way it was. And I do not know if I ever will again." The courtroom was completely silent. I looked at Tyler Brennan. He was looking at his phone. I have learned, over 23 years on this bench, that there is a particular kind of silence that a courtroom produces when something true and painful has just been spoken inside it. It is not an empty silence. It is a full one, the kind that presses against the walls and sits on people's shoulders and makes even the most restless person in the gallery go still, because something has just been said that is larger than the room and everyone present can feel it. Mrs. Eleanor Watts had just told this courtroom that a 19-year-old boy had taken away the only place in the world where her grief went quiet. She had done it without drama, without performance, without a single wasted word. She had set a photograph on my bench and told me about Harold, and then she had stood there in her carefully pressed gray coat with her fractured wrist and her healing ribs and she had let the truth of it fill the room. That silence lasted about 4 seconds. Then I looked at Tyler Brennan and asked him if he had heard what Mrs. Watts said. He shifted his weight. "Yeah," he said. "I heard her." He was not looking at Mrs. Watts. He was looking at me, which told me everything about how he had processed what she said, as information directed at the proceedings rather than words spoken by a human being about another human being's loss. "Look," he continued, "I already said I was sorry. Before I came in here, I said I was sorry. What else do you want from me?" That was the sentence exactly as he delivered it. Not what else can I do, not how can I make this right, what else do you want from me? As if the apology were a bill he had already paid and he was standing at the counter waiting for someone to acknowledge the transaction and let him leave. I want you to understand what that felt like in that room. Mrs. Watts was standing 3 feet from this boy. She had just told him, in plain and careful language, that he had taken something from her that could not be itemized in a court file, something that lived in the specific geography of a Wednesday evening walk and 31 years of marriage and a man named Harold who turned his face toward his wife mid-conversation on summer evenings. And Tyler Brennan's response was to look at the judge and ask what else we wanted from him. I asked him why he had fled the scene. He exhaled through his nose, the way people exhale when they believe a question is beneath the intelligence of the person being asked to answer it. I told you, he said. I panicked. I'm a teenager. That's what teenagers do when something goes wrong, they panic and they make bad calls. You can't hold that against me like I'm some kind of criminal. I let that sit for exactly 1 beat before I responded. Mr. Brennan, I said, you are charged with a crime. That is the definition of what we are doing here. He looked at me and something changed slightly in his expression, not remorse, not even discomfort, but a kind of recalibration, like he was deciding to try a different approach since the first one had not worked the way he expected. He almost smiled. It was not a warm smile. It was the smile of someone who has decided that the situation is slightly absurd and wants the room to know he has noticed. I made a mistake, he said. I get it. But I thought this was supposed to be a courtroom. I didn't know it was going to be a therapy session for old ladies. Somewhere behind him, in the gallery, someone exhaled, a sharp, audible breath, the kind that is not quite a gasp but carries all the same weight. I did not look to see who it was. I kept my eyes on Tyler Brennan, and I kept my voice exactly where it had been, level and unhurried, because in my experience nothing communicates authority more completely than a man who does not raise his voice when someone has just said something that deserves a response. I began going through the specifics of the charges. The speed. The residential neighborhood. The parked vehicle. The sidewalk. The hydrant. The injuries sustained by Mrs. Watts and what those injuries meant for a 67-year-old woman with osteoporosis who had spent 4 days in a hospital and would spend 4 months in physical therapy. I was perhaps 2 minutes into this when I noticed Tyler's eyes drop. Just briefly. Just for a second. But they dropped to his right hand, where the phone was, screened down against his palm. Mr. Brennan, I said. Put the phone away. He looked up. He reached into his jacket pocket with his left hand and he placed the phone inside it, slowly, with a deliberateness that communicated clearly that he was doing this on his own schedule and not mine. Sorry, he said. Just my mom. He said it lightly, like a small joke between us, like we were two people who understood together that the situation was slightly ridiculous and he was being a good sport about it. I did not respond to that. I returned to the charges. I explained to him the legal weight of a hit and run in the state of Rhode Island. I explained what fleeing the scene of an accident involving injury means under statute, and why it is treated with the seriousness it is treated with, and what the range of consequences looks like for a first offense when the circumstances include the level of recklessness documented in his case file. I was measured and I was thorough, because Tyler Brennan deserved to understand exactly what he was standing in front of, and because Mrs. Watts, who was still standing a few feet away from him, deserved to hear it said clearly in this room. That was when he interrupted me. With respect, Judge, he said, and people who begin sentences with respect almost never mean it, she wasn't even hit by my car directly. She fell because of a hydrant. I mean, that's not really on me. Is it? To my left, Mrs. Watts closed her eyes. Not dramatically. Just quietly, the way you close your eyes when something lands on a place that is already bruised. Across the gallery, a woman in a blue jacket brought her hand up slowly and pressed it against her mouth. The teenage girl I had noticed near the back of the room was staring at Tyler Brennan with an expression I recognized, the expression of someone watching something they will remember for a long time, not because it was impressive but because it was instructive in a way they had not anticipated. I set down the pen I had been holding. Mr. Brennan, I said. The fire hydrant was struck because your vehicle struck it. Mrs. Watts was injured because your vehicle struck it. The fact that the impact was indirect does not make it yours to dismiss. Do you understand the difference between a technicality and a responsibility? He opened his mouth. I continued before he could use it. You were traveling at 58 miles per hour through a neighborhood where children ride bikes and elderly women walk home from the market on Wednesday evenings. You destroyed a parked vehicle. You tore a fire hydrant from the ground. You put a 67-year-old woman in the hospital for 4 days and on a physical therapy table for 4 months. And then you ran. That is what is on you, Mr. Brennan. All of it. I told him that at 19 years old he was a legal adult in the state of Rhode Island and in this courtroom, and that he would be sentenced as one. My voice had dropped, not in volume but in register, lower, slower, with the particular weight that I have learned, over 23 years, communicates more clearly than any amount of volume that something important is about to happen and the time for negotiating the terms of the conversation has passed. Tyler Brennan's jaw tightened. I watched him look at me. Then he looked to his right, at the other defendants sitting in the gallery rows, waiting for their own cases. He looked at the court officers standing near the door. He looked at the people watching from the public gallery, the woman with her hands still at her mouth, the veteran near the back, the teenage girl who had not looked away from him once. He looked at all of them, slowly, and I could see him calculating something, the way people calculate when they have decided that an audience changes the terms of a situation and they are deciding whether to perform for it or be silenced by it. He looked back at me. You know what, he said. His voice was louder now, not shouting yet, but raised, with an edge in it that had not been there before, the edge of someone who has decided that dignity requires a response and performance is the only version of dignity he knows how to produce. I'm sorry, but I'm not going to just stand here and let you lecture me in front of all these people. You don't know me. You don't know my life. He paused for exactly 1 second, and in that second the courtroom was so quiet I could hear the ventilation in the ceiling. You can't judge me. The court reporter's fingers stopped moving. They had been transcribing continuously since the session began and now they simply stopped, resting on the keys, because the fingers belonged to a person and the person needed a moment to absorb what had just been said. Christina looked up from her desk. And Mrs. Eleanor Watts, who had been standing with her eyes closed since Tyler had told me the hydrant wasn't really on him, opened them. There is a moment that comes in certain hearings, not often, maybe a handful of times across a career, where everything that has been building in a courtroom arrives at a single point, the way a storm that has been gathering all morning finally makes itself known not with wind or noise but with a particular quality of stillness that tells every person present that what comes next is going to matter. I have felt it before. I felt it that Tuesday morning at 9:41 when Tyler Brennan looked at me in front of a room full of people and told me I could not judge him. I did not respond immediately. I have learned that the impulse to respond immediately to provocation is almost always the wrong instinct in this room. What a courtroom requires is not speed. It requires weight. And weight requires a moment to gather itself. I reached up and removed my glasses. I set them down on the bench in front of me, carefully, parallel to the edge, the way my father used to set down his tools at the end of a long day, not carelessly, not dramatically, but with the deliberateness of a man who understands that the way you handle things communicates something about how seriously you take them. Then I stood up. I do not stand often during hearings. Christina will tell you that. In 23 years, the people who appear regularly in this courtroom have come to understand that when I stand, something has shifted, that the proceeding has moved into different territory and the terms of the conversation are no longer what they were 60 seconds ago. Several people in the gallery sat forward slightly when I rose. The court officer near the door straightened. Christina folded her hands on her desk and did not look away. I looked at Tyler Brennan for a long moment without speaking. He was still standing where he had been, but something had changed in his posture, not remorse, not yet, but a first faint awareness that the ground beneath this conversation had just moved in a direction he had not anticipated. The raised voice, the performance for the gallery, the 11 words he had just delivered with such confidence, they were hanging in the air of the courtroom and he was beginning, I think, to feel their weight in a way he had not felt it when he said them. Mr. Brennan, I said. My voice was not loud. It did not need to be. In 23 years on this bench, I have had drunk drivers stand where you are standing and tell me they were simply unlucky. I have had people with prior records, people who had been through this courtroom 2 and 3 times before, look me in the eye and tell me the system was unfair and they were the ones being wronged by it. I have had people cry in front of me and people beg in front of me and people threaten me in front of me, and I have watched the bailiff walk people out of this courtroom in handcuffs for all of those things and for things worse than all of those things combined. I paused. The room was absolutely silent. But in 23 years on this bench, I said, I have never, not once, had a young man stand in front of a 67-year-old widow who can no longer walk the street where she feels close to her dead husband, and look at the judge handling his case, and tell him that he cannot be judged. I let that sit. I let it sit the way you let something sit when you need the room to understand that you are not moving past it, that this is not a point in a list of points, that this is the thing, the center of everything that is happening in this room right now. Tyler Brennan said nothing. For the first time since he had walked through those doors at 9:06 with one AirPod in and his phone in his hand, he had nothing to say. Let me tell you something about judging, I continued. My father came to this country from Italy with nothing in his pockets and a willingness to work that I have spent my entire life trying to live up to. He worked construction in the Providence cold. He worked nights when nights were available. He worked weekends. He took every job that was offered to him and he did every one of them as well as he was capable of doing it. And in all those years of working, in all those years of foreman and job sites and cold mornings and hard physical labor that wore his body down in ways he never complained about, he never once looked at the man who was evaluating his work and said, "You cannot judge me." I came around the bench. Not quickly. Deliberately. I walked down the 2 steps and across the floor of the courtroom and I stopped approximately 2 feet from Tyler Brennan. This is something I do rarely. The distance between the bench and the defendant is not arbitrary, it is architectural, it is intentional, it communicates the structure of what this room is and how it operates. When I close that distance, I am communicating something specific. I am communicating that this has stopped being procedural and has become personal, not personal to me, but personal to the truth of the situation, which sometimes requires proximity to be felt properly. Tyler Brennan did not step back. I will give him that. He held his ground physically, though everything else about him in that moment had grown smaller and quieter than it had been 60 seconds ago. You know why my father never said that? I asked him. You know why a man who worked in the cold and came home with concrete dust on his hands and got up the next morning and did it again never once told anyone they had no right to evaluate him? Because he understood something that took me years to fully appreciate and that I am going to tell you right now, free of charge, in this courtroom, in front of every person in this room. He understood that accountability is not an insult. Accountability is a gift. It is the thing that says, someone still believes you are capable of being better than you are right now. Someone still thinks it is worth the effort to hold you to a standard. The day no one holds you accountable anymore is not a day of freedom. It is the day everyone has given up on you. I looked at him steadily. He was looking back at me. The smirk was gone. The performance was gone. What was left was a 19-year-old face that was working very hard to stay composed and not entirely succeeding. You told me I don't know your life, I said. You're right. I don't. I don't know where you grew up or what your mornings look like or what it was that put you behind the wheel of that car on a Wednesday evening going 58 miles an hour through a neighborhood where people walk home from the market. I don't know any of that and I'm not going to pretend I do. But here is what I know, Tyler. I have been calling him Mr. Brennan all morning. I used his first name deliberately, and I saw him register it, saw the slight change in his eyes that told me it had landed differently than anything else I had said. Here is what I know. On a Wednesday evening 3 weeks ago, a 67-year-old woman left her house to walk to the market 2 blocks away, the same walk she has made every Wednesday for years, on the same street she walked with her husband for 31 years before he died and left her alone with her grief and her groceries and her Wednesday evenings. She was carrying 2 bags and thinking about Harold. That is what she was doing when she heard your engine. That is where she was when the hydrant hit her. That is what she lost when she could not stand up from that pavement without help, not just her ribs and her wrist and 4 days of her life in a hospital bed, but the one place in the world where the grief went quiet. I paused. And then you ran. The courtroom was so still that I could hear someone in the gallery breathing. I did not break eye contact with Tyler Brennan. He did not break it either, but his jaw had tightened again and his eyes were doing something they had not done all morning. They were working, turning something over, processing something that was costing him more effort than anything else in this room had cost him yet. You want to know what judging you looks like, Tyler? I said. It looks like this. It looks like standing 2 feet from you and telling you the truth about what you did and what it cost another person and what it means that you are 19 years old and standing here in front of it. That is what judgment looks like. Not condemnation. Not dismissal. Truth. I looked out at the courtroom, at the gallery, at the people sitting in those rows who had come in that morning with their own cases and their own worries and who had instead watched this unfold in front of them. An older man near the back with a veteran's cap folded in his hands. The teenage girl who had not looked away once. The woman in the blue jacket. Mrs. Eleanor Watts, standing exactly where she had been, watching me with an expression that I can only describe as the expression of someone who came to this room hoping to be seen and is, for the first time in 3 weeks, beginning to feel that they have been. If you believe that 19 years old is old enough to take responsibility for what you put into motion, that no one, regardless of how young they are, regardless of how expensive their jacket is or how many AirPods they own or whose therapy session they think they are too important to sit through, gets to decide that accountability does not apply to them, then stay with me. Because what I am about to hand this boy is going to do one of 2 things. It is going to break his arrogance so completely that nothing is left. Or it is going to build him, slowly and with great difficulty and at considerable cost to his Saturday mornings, into someone worth knowing. Either way, it starts right now. I walked back to my bench and sat down. I folded my hands and I delivered the sentence. Your driving license is suspended for 18 months, effective immediately. You used that license as a weapon on a residential street. You do not get it back until you have proven you understand what it means. You will pay $2,400 in fines to the court, and you will pay full restitution for Mrs. What's medical expenses and the repair costs for the damaged vehicle? Every dollar. I don't care how long it takes. Then I told him the part that mattered most. You will complete 90 days of community service through the Providence Senior Companion Program. Every Saturday morning, you will walk assigned routes with elderly residents who can no longer walk alone safely. You will do for strangers what you took from Mrs. Watts. Additionally, every month for the next 6 months, you will submit a 1-page written account to this court describing someone you walked with, what they told you, and what you learned. And within 30 days, you will return to this courtroom and deliver a written apology to Mrs. Watts, read aloud, in front of this court. Tyler's mouth opened. That's almost a year of my Saturdays. Mrs. Watts lost her Wednesdays, I said. Consider yourself fortunate I'm only asking for your Saturdays. He went quiet. Something moved across his face, not remorse yet, but the first crack. The wall coming down slightly, not from punishment, but from the precision of why. The veteran near the back nodded slowly. The teenage girl stared at Tyler like she was watching something real for the first time in her life. Mrs. Watts unfolded her hands. Thank you, Your Honor, she said quietly. Then she looked at Tyler directly. I hope you come to love walking, young man. Harold always said you can solve most things with a good long walk. Tyler looked at her. For the first time all morning, he had nothing. 4 months later, Tyler Brennan came back to my courtroom. No designer jacket. No AirPods. Plain clothes, hands at his sides, and something different in his eyes, not age exactly, but weight. The kind of weight that only comes from paying attention to other people's lives. He had completed 64 of his 90 Saturdays without missing one. Every monthly report had arrived on time. He handed me the latest one across the bench and I read a line from it aloud. Mr. Caruso is 81. He lost his wife in February. He doesn't say much, but he walks fast like he's going somewhere important. I asked him once where he was going. He said nowhere. I just like to remember what moving feels like. I think about that a lot now. I set the report down. Mrs. Watts was seated in the front row. She had agreed to be present. Tyler turned to face her. Mrs. Watts, he said, I walk your route now. Every Wednesday. I don't know if that's strange or if it helps. But I walk it because I think I owe it to you and to Harold to make sure someone sees it. She stood. She crossed the room and took both his hands in hers and she didn't speak for a long moment. Then, Harold would have liked you, she said. The version of you standing here right now. Tyler broke. One sharp breath. Eyes down. The way young men cry when they are trying not to. My father used to say, the most dangerous person in any room is someone who thinks they cannot be judged. Not because they are bad. Because they have closed the door to becoming better. Tyler Brennan walked into my courtroom and slammed that door in everyone's face. And then, because justice gave him no other choice, he opened it back up. What walked in was a boy who thought he was untouchable. What walked out, eventually, was a young man who walks with old people on Wednesday mornings and writes 1 page a month about what he is learning from them. That is not punishment. That is transformation. And that, after 23 years on this bench, is still why I love this job. I'm Frank Caprio. Remember, you can always judge a person. The real question is whether you judge them toward punishment, or toward purpose. Thanks for listening. And God bless.